Good afternoon, everyone, and welcome. My name is Tona Boyd, and I'm the Associate Director Counsel for the Legal Defense Fund. LDF is the nation's oldest racial justice legal organization, and since our founding by Thurgood Marshall in 1940, we've worked to build a multiracial, multi-ethnic democracy where dignity is sacred, power is shared, and thriving is the standard. We've done that in part by focusing on protecting and empowering Black voters, including by litigating extensively under the Voting Rights Act. We are thrilled to sponsor this discussion at a critical time in our democracy, and I want to thank Congresswoman Sewell and her team for their partnership in bringing us together today. Rep. Sewell, of course, is the lead sponsor of the John R. Lewis Voting Rights Advancement Act in the House, and she's a champion for voting rights from the birthplace of our democracy in Selma, Alabama. As we meet here today in the final week of Black History Month, we're mere months away from an election where our democracy is truly on the ballot. We're days away from the 59th anniversary of Bloody Sunday and the Selma Bridge crossing that brought us the Voting Rights Act. And a series of direct attacks on that landmark legislation are moving through the US court system as we speak. We are also awaiting a ruling from the Supreme Court any day now on a critical racial gerrymandering case that we'll discuss further here today. We're looking forward to the John Lewis bill being reintroduced in the US Senate very soon. So against that backdrop, I look forward to the conversation. We have a very distinguished panel with us today because we're short on time and everyone has more accomplishments and accolades than I can list in the hour that we have together. Our team will post the panelist bio in the chat. I'll just say that we have two of the nation's top voting rights litigators who have practiced and even argued in the Supreme Court in ACLU's Adrielle Cepeda-Derieux and LDF's own Leah Aden. And we have two courageous clients who have put their time, their energy, and their names on the line to stand up with their communities, and Evan Milligan of Allen versus Milligan, and Taiwan Scott of Alexander versus South Carolina NAACP. We'll leave a few minutes for audience questions at the end, so please do use the Q&A function to enter questions as they come up, and LDF Senior Policy Counsel Adam Leoz will moderate the question and answer session at the end of our conversation. So let's jump right in and get to the big question before us today. What is the state of voting rights for Black Americans right now? I want to kick it over first to our amazing clients who can tell us how this question is playing out in their communities and on the ground. So I'll go first to Evan. What is the state of voting rights for Black Americans right now?
Thank you, Tanya. And I'll answer that question by referring to our context here in Alabama. I've had a chance to serve as executive director of Alabama Forward since our founding in 2020. And this Friday, I'll actually be stepping down from the staff team, and our amazing deputy director, Deanna Fowler, will become interim director. And one thing that we've learned is that leadership development is very serious. We can't rely on one leader, one generation, network, team, or even one perspective or ideology, particularly in a state that has challenges that are as entrenched as here in Alabama. We need the deepest possible pool of leaders. And we now have a huge multi-layered leadership opportunity, leadership development opportunity in Alabama with Congressional District 2. And this is the district that was produced as a result of our victory in the Allen versus Milligan lawsuit. There are 19 candidates running for the seat, and they all have an opportunity to develop the broader analysis that's needed to run an effective congressional race. Prior to this suit, Congressional District 2 was about 59% white and 31% Black. And due to the court order redrafting secured by the legal team that LDF led, Congressional District 2 is now 48.7% Black. So this is now a district that can be represented by a candidate that Black voters elect if the turnout matches the potential. And this is important because in this district, in our state, we have the nation's lowest life expectancy rates, highest rates of maternal mortality and infant mortality. And District 2 features many residents who drive over an hour or more for prenatal care and other basic hospital services. Similar to Congressional District 7, represented by Congresswoman Sewell, District 2 also features many households who still lack sanitation infrastructure in their communities. Montgomery, Mobile, and Macon County, which are also a part of this new redrafted District 2, those communities feature some of the highest rates of community violence in the country in a state with the worst ratio of mental health care services. Our community violence prevention and intervention infrastructure is at the earliest stages of development, and many who could be doing that work aren't aware of the federal funding that could support them. So congressional leaders from backgrounds that reflect the diversity of the people they serve can impact each of these areas by securing public and private investment in our infrastructure. Those leaders can ensure that the cycle of leadership development continues by supporting expansive voting rights protections that bring more people into the political process. So where we are now, the state of voting rights in our communities, we need people that can speak to those social factors that I just mentioned, and certainly speak in a way that inspires so many others who've been looking at government services as a reason not to be involved in the process. They have to, here in our state, we actually have to ask people to believe in things that they haven't seen. And that takes dynamic dynamic leaders and people who actually have emotional experiences that mirror the folks that they're wanting to inspire. We're hoping that we see that occur in this race for this new congressional seat.
Thank you so much, Evan, for that perspective and for really bringing it home about why representation matters. Ty, I want to turn to you. And before I do, I just want to remind all participants that the webinar is being recorded. So Ty, turning to you, what is your perspective here? What is the state of voting rights in Black America? And why does this matter? Why does representation matter?
The first thought to me really comes down to it's scary. It's sad to see that in this day and this time we're still fighting for our constitutional rights to have a voice, to be able to elect someone that will be an advocate to speak out and speak up, for our historical concerns. It just behooves me to see that just the basics we're still fighting for. Our ancestors have gone through this already, and it's being challenged on a daily. So we have to be able to have that advocate that can speak up and speak out. Being in the Gullah Geechee corridor myself, in Hilton Head, the heart of the corridor, land loss, flooding, infrastructure, roads. I mean, all of this is impactful and is detrimental to our survival of the Gullah culture here on Hilton Head and within the corridor. So it really comes down to having that voice, being able to elect someone who can, and again, continue to speak up and speak out. And we should not be going through this in this day and this time. We matter. I mean, our voices matter and we need to be heard.
Thank you so much for that, Ty, and thank you both for sharing your perspectives and for your service to our democracy. I want to turn now and bring our litigators into the discussion to talk a little bit about the role that courts play in this important conversation. So let's start by talking about the Voting Rights Act. In just over a decade, we've had Supreme Court cases on 3 of the core pieces of the Voting Rights Act. The pre-clearance protection was gutted really in Shelby in 2013. Protections against voter suppression or vote denial were dealt a blow in the 2021 Brnovich case. And just last year, the Milligan case provided a helpful reaffirmation on vote dilution and that provision of the law designed to prevent the watering down of the power of voters of color. So Leah, let me start with you. Can you sum up the state of the law when it comes to the Voting Rights Act after these 3 big cases?
Good afternoon, everyone. Yes, I'm happy to respond to that. So as you've heard from Evan, among others, the Voting Rights Act remains a vital core protection that we still need to upend discrimination after it takes place. So you've heard that the VRA at great time and with great financial cost, responded to the failure of certain leaders in Alabama and Louisiana, places like Louisiana, to adopt additional opportunity to elect districts following the 2020 census. In addition to using Section 2 of the Voting Rights Act robustly, like in Alabama and Louisiana, we still need to have a robust pre-clearance framework under the VRA and to have other federal and state protections in order to stop harms before they take place, before elections occur and before people benefit from discriminatory districts and bills. So for example, we need tools like those that have been introduced legislative session after legislative session and hopefully forthcoming in this legislative session that prevent redistricting in places like Galveston, Texas, that backslid by decimating the only ability to elect commission district for Black voters after the 2020 census. In the vote denial context in places like Georgia, Texas, and Florida, we need protections to prevent what transpired after the 2020 elections that we're still fighting for, which is the immediate adoption of mechanisms to prevent the strong electoral participation that voters of color had in the 2020 elections. But what is important is that, at least in the vote denial context, although the court has reaffirmed the vitality of the Voting Rights Act in the Section 2 in the redistricting context, courts have been reluctant to find discriminatory impact with respect to voter suppression bills, even when thousands of voters have been harmed, because courts have been finding that the disparities aren't significant enough, even when voters, or Black voters in particular, are disproportionately impacted. And courts have allowed states to use the ruse of protecting against non-existent voter fraud and shoring up purported voter confidence in order to pass monster omnibus bills across the country. So we still need this preclearance mechanism to stop the backsliding. And I would be remiss if I did not mention that we haven't begun to scratch the surface in trying to uproot a lot of the discrimination at the local level, which remains very important when we're talking about our school boards, our city councils, our county commissions. Most of the work that Evan and Ty have been doing has been to confront congressional redistricting, state legislative redistricting, but there is a lot of work to do at the local level. And that is something that is incumbent upon us to focus on. In addition to, we will have upcoming elections in 2024. We do not know what discrimination will flow from it, but we and others in that vacuum of leadership that Evan and others are pouring into are going to move us forward to challenge what is ahead of us.
Thanks, Leah. I want to turn now to Adrielle. While Section 2 of the Voting Rights Act remains a potent tool, as Leah just said, thanks to Evan and others, we also know that we're facing direct attacks on this pivotal provision of the law, and the ACLU has really been on the front line fending off those attacks. Can you tell us more about the work that you're doing?
Sure. Thank you so much, Shona, and thanks to LDF for gathering us here today. It's wonderful to be here with such great friends in the trenches and those we fight for. So at the ACLU, we've been busy having the honor to fight side by side and shoulder to shoulder with LDF on cases like Evan, like Ty's, and our redistricting litigation in Louisiana as well. We've also challenged statewide maps on behalf of Black voters in Georgia and Mississippi, in Arkansas. And I'll mention Arkansas because that's a great place to start when we talk about attacks. In Arkansas, we challenged the state's House maps on behalf of the NAACP State Conference. Now, unfortunately, even though we had what the district court called a very strong case on the merits, the district court made a radical ruling and for the first time ever held that Section 2 of the Voting Rights Act doesn't have a private right of action. It doesn't give private voters like Evan, private voters like Ty, a chance to vindicate their voting rights under that statute. Instead, the court said that only the U.S., only the Attorney General can bring those claims. Now, that is radical because it ignores the hundreds of cases that have been litigated, certainly since 1965, but for sure since 1982, when the modern version of the Voting Rights Act took form. It ignores cases like Allen versus Milligan. And we appealed that ruling because it was such an outlier. But unfortunately, in November, the Eighth Circuit then became the second court to ever rule that way and said that there is no private right of action specifically under Section 2 of the Voting Rights Act. Now, the Eighth Circuit has declined a request to consider that decision en banc for the full court to review that panel's error. It was a split decision, I should say. It was a one judge dissented. So what we have now is that for the first time, one of the federal courts of appeals has said that private plaintiffs can't bring their own cases under Section 2 of the Voting Rights Act. And at the moment, we are carefully talking to our clients and weighing the pros and cons of taking that case up to the Supreme Court. Now, one thing to be clear on here is that there are pros and there are cons. And one thing that we've been very careful is the fact that cases are proceeding under Section 2, even in the Eighth Circuit under other statutory provisions. I don't want to get too in the weeds, but there's a federal statute, Section 1983, that gives private plaintiffs the right to bring their federal voting rights challenges under that provision. And we've seen attacks on the private right of action get beaten back in Louisiana, in Georgia, in Kansas. But the fact that we're here at all only highlights the threats and the intensity of the attacks that the VRA faces, because this was truly unthinkable a decade ago, if not to say even 5 years ago. I'll also mention coalition districts, and we've seen defendants take aim at the notion that the Voting Rights Act protects minority coalitions. Leah mentioned Galveston. So there we saw private plaintiffs and the federal Justice Department score a huge win against local maps, against Galveston County local maps where Black and Latino voters have been historically underrepresented. And they did that in part because the Fifth Circuit has for decades said that Black and Latino plaintiffs may pool together to get the relief that the VRA gives them. But Galveston has now appealed that and has taken that case en banc. It'll be heard, I believe, in May. So that notion that minority communities can pool together to elect candidates of their choice is also under threat.
Thanks, Adriel. I want to turn now to additional protections that exist under the law for Voting Rights Act. So for voting rights. So beyond the Voting Rights Act, the Constitution itself contains some protections for Black voters. Leah, can you briefly summarize these protections?
Sure, and I'll take on just a few of them. Under the 14th Amendment, actors cannot excessively use race in their decision-making without a compelling interest, such as complying with the Voting Rights Act. And of course, though, you can be race conscious, that is okay. But it's the excessive use of race that is subject to the strictest of scrutiny. So in redistricting cases that we've talked about, from South Carolina to Texas to Georgia to Florida to Arkansas, one of the theories is that officials place voters in and out of districts because of their race, predominantly because of their race, subverting all other considerations such as respect for counties, respect for communities of interest, and they had no good reason to do so, such as compliance with the Voting Rights Act. There is a separate analytically distinct claim that we see plaintiffs using across the country under the 14th and 15th Amendments, which is that actors can have a goal to purposefully harm voters of color, their electoral opportunity, their ability to elect their preferred candidates without a good reason. And so we've seen in both the redistricting context and in the voter suppression context and challenges again in South Carolina, Texas, Georgia, Florida, Arkansas, really all over the country, this theory that officials adopted a discriminatory measure, omnibus voter suppression bill, a redistricting map, because they intended to limit the electoral prospects of a plaintiff group, a minority group. And both of these theories have had some success in the courts, but they are often done alongside where possible Voting Rights Act claims and other claims in order to show that there are various ways that voters are harmed, and frankly, litigators and their partners, their plaintiffs, are using every theory that's available to them to try to remedy the harms that we're seeing.
So Leah, you in October argued before the Supreme Court in Alexander versus South Carolina NAACP, and you skillfully, I must say, handled a barrage of questions from Justice Alito with grace and strength. And I can say, I think on behalf of LDF and our partners in the voting rights community, you really did the ancestors proud. Can you tell us how this case is different from Milligan and its broader implications?
Yes. As you've heard, Milligan is largely about enforcing the requirements under the Voting Rights Act, and it involved a challenge to the failure of officials to create an additional opportunity to elect district where the conditions exist in Alabama for that, namely cohesive communities of Black voters and differing voting preferences of Black and non-Black voters. And importantly, Milligan reaffirmed the vitality and the continued importance of the Voting Rights Act and Voting Rights Act compliant districts in all its forms. Alexander, the case arising out of South Carolina, is not about the Voting Rights Act or the failure to create additional districts beyond the one congressional district in place in South Carolina. It involves separate claims under the Constitution, like the ones I described in response to the last question, and that at the heart of it, that officials sorted voters on the basis of race, party affiliation, traditional redistricting principles do not explain the sorting, and they had no good reason to excessively use race in creating congressional districts. There's also the added claim that I mentioned that they set out to create a congressional district at issue in order to minimize Black voters' power, which they have in the state. Why I think this case is important, and I hope Adriel and Ty agree with me, is that the Constitution protects Black voters even when we're not talking about the creation of additional opportunity to elect districts, majority, minority districts. It protects when Black voters are packed and cracked, and race is the predominant means for them doing it. And importantly, we have to continue to make clear that voting rights of Black voters, they matter even when Black people are not the majority of a district. You cannot just treat Black voters any old way, even when they're not the majority of the district. And finally, I think this case is important because it should reaffirm this well-established principle that you cannot use partisan justification as a ruse to harm Black voters. That if sorting or cracking and packing Black voters because of their race is your primary vehicle, even to achieve partisan advantage, that can run afoul of the Constitution, and people should not be able to hide behind partisan advantage in any of their decision-making.
Thanks, Leah. Ty, I want to turn to you now. You were in the room that day. Tell us what it was like to see Leah up there advocating on your behalf, and tell us what's at stake for your community in the Alexander case.
It was wonderful. It really was watching Leah basically take her position. You know, it was sad to see that she had to basically relitigate, you know, what was already heard in federal district court. But it was great to see that she held and she spoke for us and spoke for the people here within Congressional District Number 1. I look at our particular area and I say to Congress themselves, I mean, you have dedicated a corridor to the Gullah Geechee people. You know, we matter. You know, we should matter. Our voices should matter. But we have historical issues that continue to be on the table and not being resolved. I mean, how can you lose your historic land in a year and a day for not paying taxes? I mean, something is wrong with that. I mean, we need those advocates who's going to be able to speak up and speak out and be our voice. And just seeing that we're still faced with these outstanding concerns, land use, not being able to utilize our land, economic development opportunities. I mean, these are real. These are real issues and real concerns that are faced, that we continue to face within our congressional district. I mean, throughout the corridor. So I question again to Congress. I mean, you've pointed the finger and said, here are a group of people, but something has to happen more than just talking. I mean, we have highways that's being placed in our historic Gullah communities. I mean, we have airports that are expanding within our historic Gullah communities. I mean, where are our voices to stop that kind of thing from happening? When I came to live in Hilton Head, I grew up here as long as I can remember. But one of the things that still resonates in my ears is an elder Native Islander saying, zoning and ordinances is the newest form of discrimination. I mean, we're still faced with that now. So we have to be able to elect someone who sees that, understands that, and will be an advocate to put a stop to that. But it was great. It was great to see Leah stand up. It kind of reminds me when she came here to Hilton Head, and one of the officials, we attended a local meeting, and they basically said to Leah, "Are you here to keep Ty in check?" And without a blink of an eye, she said, "Well, we're here to watch you." And it was amazing to see that. And that's Leah, that's LDF, Janae, I mean, everybody there, working with the team, ACLU. It was a great experience, and I'm hopeful that the Supreme Court will unanimously agree with the federal district court. I think it's obvious what's been happening and continue to happen to us.
Thank you so much for that perspective, Ty. It's critically important to hear what actually impacts folks on the ground. I want to remind our guests today to please put any questions you may have for our panelists in the Q&A part of the chat. And I want to turn now back to Adrielle and ask you, as a key part and partner of the legal team in Alexander, why is it important to have multiple tools to protect voters beyond the Voting Rights Act?
Yeah, that's a great question. I think it's just crucial to have as many tools as possible, because as Leah spoke, the discrimination or the effects of discrimination can take many, many forms. We also know from these fights, just the cycle, but certainly from cycles past and from decades before, that those who oppose the vision of an inclusive democracy that we have here are going to be relentless. So even when we restore the VRA to its full strength, and I'll say when, there will be challenges, not just practical challenges, but legal challenges to that law. So what we've seen in the last few years is really advocates in the last few years, and I should say probably since going back 11 years to Shelby, which really kind of sounded the starting gun on this this run of voting rights litigation, is advocates having to turn to every possible tool, and some that, quite frankly, we'd not really used before. So, I'd like to raise Georgia as an example, which passed a law, SB 202, which banned folks from giving voters food and water while they stand in line. Now, we know that this law disproportionately affects Black voters because that's where the lines are. But after a case like Brnovich, for example, we also know that the road to a win under Section 2 litigation might be tougher. So again with the LDF turn to the First Amendment, because not letting folks give each other water when they're standing in line to vote also silences their expression, also silences the very important message that voting is crucial to their democracy and to their communities. And in other places like Texas and Mississippi, where states have made it harder for voters to help others send an absentee ballot, we've seen the voting rights community turn to laws that ban discrimination on the basis of disability, like the ADA or Section 208 of the Voting Rights Act, which again wasn't really used as much until recently. I will say here that one cause for hope and one wonderful thing to have seen come together, certainly in the last 2 years, has been the work of state legislatures enacting homegrown voting rights acts, which is somewhere where LDF has also brilliantly led, and where we've been happy to stand shoulder to shoulder with LDF on. States like New York, like Connecticut, have woken up and passed strong voter protections, and we're starting to see them have teeth. Just last month, the ACLU, along with partners like Latino Justice and the Asian American Legal Defense Fund, sued in Nassau County, which drew an awful and dilutive map that makes it terribly difficult for Black, Latino, and Asian voters to elect candidates of choice. So we need all the tools we can have, because we will have to use them, because those who oppose an inclusive democracy are relentless, are tenacious, and the discrimination that they enact is very can take many forms.
Thanks for that perspective, and I think that's a good segue to our next section, and I'm going to stick with you, Adrielle, and discussing some of the threats that we're facing on this landscape. So we're obviously in the throes of a critical election year, and here in DC, there's been a lot of talk about the impact of AI, deep fakes, and other new challenges. What are voting rights advocates looking out for in this moment, and how prepared are we to defend Black voters with our current laws?
Yeah, there's always a new thing, right? The deep fakes are, the AI and deep fakes are deeply concerning, especially when they're used to target vulnerable and marginalized communities. In the last cycle in 2020, we saw robocalls used specifically to target Black communities in Detroit and Chicago, in Cleveland, in New York. So there's no reason to think that they would be used any differently this time around. I think this is something that the community is learning about and adapting to very quickly, and we need to be vigilant. But I do believe that at the end of the day, it's more classic or more understood uses of voter suppression, or those that we've seen in the past, that are worth keeping most of our focus on. Cutting voting times, purging voter lists, making voting by mail harder than it was just 4 years ago, mass challenges to voter qualifications in predominantly in areas of where it's predominantly voters of color that are voting. Those are all likely to have a broader disenfranchising effect. The disinformation that comes along with these robocalls and these deepfakes usually target folks before they vote, so the urgency is on getting the right information out there. But long lines, challenges to voted ballots, those can hurt communities at a wholesale level, and it's kind of those, I guess, to call them classic, even though I don't want to give them that status, but that sort of more understood forms of voter suppression that we are being very, very careful about.
Thanks for that, Adrielle. And just to address a quick question that came up in the chat, there was a question about what Supreme Court case Leah Aden was referencing in her prior answer, and that was Alexander versus South Carolina NAACP. So now I want to turn to the role of Congress, because many of the folks in our audience today work on Capitol Hill. Leah, turning back to you, what do you think Congress needs to do to address both the urgent and the longer-term threats to Black voting rights?
We would implore Congress to restore and strengthen the John Lewis Voting Rights Advancement Act, and also pass minimum standards for elections across the country by passing the Freedom to Vote Act. So the John Lewis proposed bill would address a lot of the threats that Adrielle mentioned, from clarifying the existing right of folks like Evan and Ty and many others to continue to bring Voting Rights Act litigation under the VRA, and to clarify that coalition claims such as in Galveston, Texas, or in the Texas state redistricting, they are available where the conditions exist, and that's not going to be everywhere, but where plaintiffs can prove them, they should have that as a means to have redressability. And the John Lewis Voting Rights Act would fix the problems that we have seen over the more than past 10 years with the fallout from the Shelby County decision, and also the retreat on the robustness of the Voting Rights Act with the Brnovich decision of 2021. So that piece of legislation, I cannot implore you, would strengthen and move us forward to be able to get to the other issues that are pertinent to Black communities beyond holding on to the protections that people have spent decades trying to achieve, and give us some minimum standards for our democracy, which would benefit really everyone in the country, not just Black voters, that would flow to the advantage of everyone in the country. So that is what we would implore people to spend much of their energy on. And again, this is not for us, for Evan, for Ty, simply a question of being able to participate and cast a ballot, but it is all the things that flow from being able to have representatives speak to your needs. And Evan and Ty have spoken about those, and there are many others.
Thanks for that, Leah. And, you know, though eternal optimists we may be as civil rights and voting rights advocates, I think it's safe to say that it's unlikely for the John Lewis Voting Rights Advancement Act to become law before the 2024 election.
We're losing you, Tona. Is it just me?
Can you hear me? Can you still hear me? Okay, Ty says he can hear me, so I'll keep going. So I was just saying, you know, we're optimists here, and we will continually fight to ensure that Black people have the representation that they deserve. But it is unlikely in this Congress that the John Lewis Voting Rights Act will pass before the 2024 election. So the final question I want to raise for the panel before we turn it over to the audience is, what can people watching, those folks who work on the Hill, what can they be doing right now to protect our democracy? And I want to kick it back to Evan for the first shot at this question.
Sure. Well, in order to have a Congress that would be willing to pass both the Freedom to Vote Act and the John Lewis Voting Rights Advancement Act, we have to have folks who are not currently enthusiastic about voting and really about the political process as a whole, find their own self-interest and find their own pathway to themselves being a part of that process. And I think that that means really relying on the folks that are working on the ground around this country, that are doing frontline work, canvassing work, and relational organizing. The data that we've seen around, you know, what actually motivates people who are less engaged to shift behavior, it comes in the form of people that they know and people who are speaking language that they understand. And I think it's really critical to make sure that volunteer hours, dollars, encouragement is floating to those networks and to those organizations. That's certainly something that we're attempting to do in the Alabama Forward Network. And I know Ty and those in South Carolina, Power Coalition in Louisiana, there are so many groups that are attempting to do that. And I think that support is really critical right now.
Thank you, Evan. I want to turn it over to Ty now.
Yes, I think definitely it's the engagement of the younger generation. I mean, you have to let them understand what matters, you know, and having our voice matters, you know, and we have to connect with them. We have to be able to see, you know, and show them, you know, what we have gone through and what we're still fighting in order to get them involved in participating with our future. I mean, it's not an easy path. You know, and you know, they say the squeaky wheel gets the grease, you know, so we have to be that squeaky wheel, and we have to keep our our boots on the ground, and just continue to just engage and speak up and speak out. And, having that will, I believe, will get the engagement that we need, and just keep pressing. We have to keep pressing forward. Again, we matter, our voices matter, so we can't give up. We've come too far to give up.
Thank you, Ty. Adriel?
I would just say that the legislation we're talking about, especially speaking to folks on the Hill, that to just keep pushing and keep keeping it on the front burner. This has to be a priority. I think history has shown that even if we think there might not be a path, moments come and then things happen very quickly. So things should just be teed up because the threats are real, and this legislation will help immensely for just everyone who does the voting rights work, but also the communities that they represent, most importantly. So just not let up and keep pushing, like Ty just said. I think that's the most important thing.
And to Leah.
I would lift up to do something in whatever your capacity is, whether that's pushing for the federal legislation, pushing for the state Comparative Voting Rights Act that Adriel mentioned. California has had a Voting Rights Act, and other states have adopted them slowly over the years, and they have really been instructive in opening up access to representation at the state and local level for Black, API, Latino, and other voters. And obviously we're coming up on an election year, and that involves public education, get out the vote efforts. It involves the fact that there's still redistricting happening across the country, not just at the federal and state level, but at the local level. There is analyzing what has happened after election and what the barriers were to people during elections, and trying to legislate and policy make around that. I mean, there's something for everyone to do, and whether you are the most savvy about the political process or you have more to learn, everyone needs to be a part of it in some way, shape, or form. And that, I think, is what everyone here has been working very hard to do.
Thank you for that, Leah. I think we have some time, and we have a few questions that have come into the chat for our panelists. So I'm going to turn to LDF Senior Policy Counsel Adam Leoz to field the questions and tee them up to our panel.
Thank you so much, Tona, and hi, everybody. Great to be with this distinguished panel and with you all today. The first question comes from Xavier, and I'm going to toss it to Ty, because Ty, you mentioned speaking directly to young folks, right? And so Xavier asks, what can young people, such as college students and recent graduates, do to disrupt the cycle and ensure we live in an inclusive democracy?
Challenge. We have to challenge the injustices. I mean, when you see it, you have to confront it head on. I mean, and sadly, like I said, you may be the only one who's willing to stand up and speak out, but you can't let that deter you. Your efforts will be rewarded. I feel as though we all have a purpose. Everyone has a purpose, and you have to. You just have to continue doing it. I mean, some people may try to discourage you and say, you're just you continue to say the same things, but eventually somebody will hear, somebody will listen, and you can't just let it discourage you. I mean, we've come so far, our ancestors have come so far, and our voices matter, and we have to just continue doing it. I mean, it's so easy to give up. It really is easy to give up, and the hardest thing to do is to fight. But it takes that. It takes that making people aware of what's happening and bringing them to a level playing field. Break it down to the ABCs for them. How are these what's happening? What's the hands-on impact of what's being passed? How is it directly affecting you? I mentioned zoning and ordinances. I mean, people can understand that. I mean, that's a hands-on direct impact on how you can keep your land or develop your land. And this all comes down to, what's being passed, by our representatives, or what's being allowed to happen. So we have to do that. Just continue pushing, continue fighting, and we'll be heard. We will be heard.
Thanks, Ty. Evan, there's a question I think that came in that you've touched on, but just to underscore, it says, beyond litigating against discriminatory practices with amazing organizations like this, or waiting on Congress to act, what should Black voters be doing right now to empower themselves in this democracy? If you could elaborate on some of the items that you already discussed, that would be great.
So I think we, Black voters should understand how much our ancestors and predecessors, and even we, have paid into this democracy, and that litigation is not an easy thing. I don't think that the gridlock Congress will just restore the VRA or pass the legislation that we've discussed today without being pushed. And pushing Congress is something that is, we shouldn't think that that's a small thing. I think there are all sorts of ways that the levers of Congress can be pushed. There are avenues of moving money to incentivize certain things. I think overwhelmingly from the groups that are gathered here today and the groups that I've worked with, we really want to see movement work push Congress in a way that reflects the interests of those who are currently receiving the least from our economy and the least from public services. So if that's really what we want, then it takes work to build that sort of infrastructure so that networks of people who in some instances are competing for resources can actually have enough trust in each other to rely on each other to do something that many of the special interest groups in this country don't even think are possible to achieve. And I think that that's sort of been par for the course for all sorts of change in this country's history, from the Pell Grant to integrating the military, or integrating anything, creating Head Start, women voting. There are always people who see the vision for that 20, 30 years before it happens. And as Ty was saying, they never give up. They never stop organizing. They never stop educating, to the point where that becomes cultural. That becomes a cultural fixture, an emotional fixture for leaders that are respected on the ground. I think we have an opportunity right now to take the narrative of democracy and root it in our work in a way that becomes emotional and cultural in that same way. And that's not going to be a win that produces, it may not produce the win tomorrow or next year, but 10 years, 5 years, 20 years down the line, as long as we plan on being alive 5, 10, 20 years down the line, if we can contribute to that every day, then those will be goals that can at least set a minimum standard for democracy in this country. And we need the Freedom to Vote Act and the John Lewis Act and these comparative, the comparative acts at the state level to achieve those things. Most importantly, it takes movements to actually yield that legislation. And so I hope that as Black voters, we understand that we're still in this process, that we don't quit and we don't just assume that the other side is so superior and they have so much power that we don't even need to attempt to compete.
Thanks so much, Evan. You mentioned the state voting rights acts, as did Adrielle and Leah, and that's one example of some innovations at the state level. So we have a question from Jake. What successes or innovations on the state level have you seen in terms of expanding or facilitating access to the ballot that you'd want to see replicated at the federal level? So that's for anyone to jump in, but maybe Leah, you want to start?
Well, I would add that we've seen it, and fortunately, because it's worked, it's led to restrictions, right? So in light of what we've seen in Georgia and Texas and Florida and elsewhere, right? Expanded use of absentee voting, expanded use of all forms of like access to the ballot on election day. That has led to historic participation, right? So Evan is talking about, people engaging. I mean, we have seen people engage. We have seen the pivotal role that Black voters have played in election after election. And that is also true of other voters of color. States are becoming more diverse. Elections are becoming close and contested in some places. And so then when people use these opportunities, what unfortunately we have seen is those are immediately attempted to be pulled back, restricted, which has then led to litigation. So I think we have to keep using those means. I think we have to keep challenging where they're restricted. I think we have to keep introducing legislation to make it so that people have all available means to participate. And frankly, we have a legacy of, in the face of that resistance, continuing to participate, because I think we recognize the relationship between our history, the fact that our participation has always been about retrenchment, and bringing more people into the fold in the face of all of that. But I think we have seen innovation, and we've seen people take advantage of the innovation. And unfortunately, we have to keep dealing with retrenchment. And that's because we don't have some of the underlying structures in place, like pre-clearance, to stop people from restricting progress from moving forward. So that would be my take on it, but I'm happy to hear other ideas.
Anyone else want to jump in on that question?
No, that about covers it. I do think, we saw a very successful election in 2020 that, because of reasons outside of anyone's control, namely the pandemic that we had going on, you saw state legislatures across the map look for ways to make it easier for folks to vote, so they didn't have to stand in line, and they didn't have to, in many ways, risk their lives to cast a ballot. And we saw that work. We saw an incredibly successful and a very high turnout election that study after study has said was safe, was not tainted by rampant fraud, despite what many would say. And what we've seen in the last few years, certainly in the legislative cycle since that election, has been the snapback, right? Because the election went ways that many in power didn't like it to have gone. Result-wise, you've seen that cutting back of those measures that actually made it easier for folks across the nation to vote. And what we need are those structures that prevent that rolling back. Most, the one that is obviously at the top of the list is something like pre-clearance that stops that retrogression from happening again.
All right, I think we have time for just another. I'm going to mush together the two last questions that we have time for and give the panelists a chance to answer before we turn it back to Tona to wrap us up. But so Julius has asked, how do we make sure that rural areas don't get left behind in this whole process? And Loris has asked about accessibility at the polling places, and how do we make sure that that is a priority for folks who need accommodations, or make sure our polling places are accessible. So let me toss that to the panel, whoever wants to jump in on either of those, and then we'll toss it back to Tona to wrap us up.
I know here in Alabama, and this builds on what was just said as far as the sort of reaction against the historic voter turnout in 2020. Here we have several bills that are sort of surging through either side of our legislature right now during the session, and one is one that would criminalize third-party organizations like our member groups providing assistance on absentee ballots. And I haven't seen, I'm not quoting the numbers as far as rural voters, but I am anecdotally speaking, and from just relational organizing, I know that absentee voting was a critical component of the historic turnout in this state in 2020. And so our absentee ballots are pretty complicated. I filled one out last week when I voted and had questions, and I have a law degree and was there with my wife who has one. So I imagine that many of our folks who are in areas where Wi-Fi is not strong, where transportation is an issue, where polling stations are more sparse, they would actually need more expansive provisions. And that's something that I think we've talked about incentives to move away from that. But again, that gets back to both understanding the need for federal protection through the bills that we've discussed, and also having movement leaders talking to each other and talking to those on the Hill and those with these legal services organizations to understand how to put the information in language and symbols that's palatable to the very people who stand to benefit the most from their passage.
All right. Well, I think that pretty much sums it up. And so I would toss it back to Tona to wrap us up for the afternoon. But thank you so much to the folks who asked questions and to the panelists for your responses.
So thank you. I know it's hard to wrap up such a robust conversation, but I want to thank our distinguished panelists, to Evan and Ty. Thank you so much for being active examples of democracy in action as the new foot soldiers in the fight for voting rights. We are grateful for your service. And to Leah and Adrielle, thank you for being on the front lines of the legal battles that will shape the voting protections that we all should enjoy. I also want to thank all of you as participants for joining us for this important conversation. LDF will continue to fight to protect and empower Black voters, just as we've done for more than 80 years. We are exploring hosting a follow-up conversation with Congresswoman Sewell's office, so look out for an invitation to a follow-on. And finally, we look forward to working with all of you to restore and strengthen the Voting Rights Act through the John Lewis bill and to provide minimum standards for voting accessibility across the country through the Freedom to Vote Act. I'll close us out with a call to action from our founder, Thurgood Marshall. He said, "This is your democracy. Make it, protect it, pass it on." So have a good day, everyone, and thanks again for joining us.